Welcome to Turnaround Talks by TMA Florida. Each month we explore quick insights, real experiences, and the trends shaping the turnaround world. I'm Nick Welch, your host for this month, and I'm looking forward to diving into today's discussion with our guest, Rob Folland. Rob, you currently serve as president of the TMA's Florida chapter, and you have consistently been recognized as an Ohio super lawyer, as well as by Best Lawyers in America for your excellence in guiding clients through bankruptcy and litigation challenges, among other legal matters. I'm excited to be here with you today, as we're going to cover one of my favorite topics, bankruptcy, and also dive into one of the lesser explored topics of personal guarantees and how they affect restructuring. Let's just jump straight into the questions here.
Sure.
So Rob, I often have clients, and especially at a certain size level, that immediately rule out a bankruptcy due to the perceived cost. Tell us, how much does a Chapter 11 cost to run for a small business?
Yeah. Well, thank you, Nick. Appreciate you inviting me out today and looking forward to talking through these issues with you. First off, on your question on costs, costs are always a challenge when you're looking at an insolvency situation. Bankruptcy is maybe obvious or not obviously, perhaps one of the most expensive options you can choose. There are a number of other options, as I'm sure we'll talk about as we get into it here today. It can range, there's always a range on price, but I would say for a middle market company with, say, 20 to 50 employees, you're looking at not insignificant cost if you're talking about a bankruptcy process, which is probably going to be in the range of $150,000 and up, depending on the complexity.
Okay, interesting. So yeah, those dollars, like you say, depending on complexity, certainly do start ramping up. Subchapter 5 of Chapter 11 is often kind of banded around as being a cheaper alternative to a full-size Chapter 11. What is a Subchapter 5 bankruptcy, and how might that help small businesses?
Well, you're using a couple terms there. So you were talking about bankruptcy. Now we're talking about Chapter 11 bankruptcy. Chapter 11 bankruptcy is called a reorganization as opposed to a liquidation. That's a chapter of the bankruptcy code. And that is unique in that a debtor acts as what we call a debtor in possession in those circumstances, which means that typically there is no trustee appointed. Now you're talking about a sub 5 bankruptcy, which is a special section for small businesses with debts up to, it changes with inflation indexing each year, but I believe for 2025, it's in the neighborhood of $3.1 million, maybe just a smidge above that. And then if your uncontested liquidated debts to non-insiders are at or below that amount, the 3.1 million, then you are eligible to file a sub 5 case in most instances. Single asset real estate and some other things might be excluded from that. But in such a case, the rules are relaxed, the costs are less, and you also, instead of having a creditors committee, will have a subchapter 5 trustee who acts in many cases as a facilitator to try to resolve and work out challenges and issues faced by the debtor. The bankruptcy fees to the United States Trustee's Office are also considerably less. So to the extent you can qualify for a subchapter 5, that's very often the optimal solution if you're locked into a bankruptcy scenario.
Okay, very, very interesting. Apart from the size limitations, what other limitations are there for a small business filing a Subchapter 5 versus a full-size 11?
Yeah. Well, the debt is the main one. Interestingly, it's debt owed to third parties. So to the extent there's a debt owed to an insider, there's been some recent case law that would indicate that that would not necessarily be included in the limitation. There are other things, certain types of situations, such as I mentioned, single asset real estate and the like, where they're not eligible to file the sub 5. But in general, to the extent that you have business debts as opposed to a individual in a non-business situation, you can file the sub 5 so long as you meet the debt limits.
Okay, very useful to know. And if a company chose not to or couldn't afford even to go through the small business Chapter 11 and Subchapter 5, what other alternatives that aren't,
Right.
kind of court supervised that might be
Yeah.
available?
Well, there's a whole waterfall that you go down from that point. Primarily, when you're looking at a Chapter 11 or the Sub 5, you're looking with at least a hope of reorganizing to have the entity emerge from bankruptcy and stay in existence. One of the things with the Sub 5 that I should have mentioned before that's interesting is you don't necessarily have to pay all your creditors in full in the Sub 5 and have them have all the creditors as a classes vote in favor of the plan. You can still maintain control and emerge from bankruptcy so long as you pay something, at least more than in a liquidation. So that's one of the advantages. If for whatever reason you can't afford the cost or the business is beyond repair, you can always look at a Chapter 7 liquidation, and that is where a trustee will be appointed by the court to supervise the liquidation. So, in essence, it's much less expensive because there's very little for the debtor to do after the case is filed. A trustee will be put in place and will marshal the assets, find out what exists, and liquidate those and use it to satisfy creditors. Costs involved in that process are primarily for the debtor to prepare the bankruptcy schedules and listing of assets, statement of financial affairs, and the like, so that a trustee, when they're appointed, can go through and look at the assets and liquidate them. One of the downsides to that, obviously, is one of the debtor's assets are claims and causes of action, potentially claims against insiders. So, to the extent you're in management of a company, you have to carefully think about what may exist and do you want a trustee to go through and do those investigations and look for those claims. Beyond that process, with a Chapter 7, there are a number of other innovative remedies and vehicles out there. For example, the state of Florida has a very robust assignment for the benefit of creditors statute that can be very useful, and that's supervised in a court process in state court. That's typically initiated with a complaint and the like, and then you follow the procedures, which are similar to a liquidation, but the advantage is you don't have a trustee. You will have an assignee, they call them, who will take over the assets and work to distribute. There are other things such as Article 9 secured party sales that may come into play. You could have a receivership, for example, and there are other types of just general managed, structured entities or organizations where you might hire a professional manager to work out of court liquidation and winding up of the affairs of the company.
Okay, very, very informative. Appreciate that, Rob. So it's good to know that for small business debtors and debtors in general, supervised process is not the only way to go, and particularly not so if cash is short. There are some other kind of remedies that can be enacted there.
Exactly.
Historically, the two, generally speaking, the two main groups of creditors in any kind of restructure have typically been secured lenders and secured creditors, and unsecured lenders and unsecured creditors like general vendors, etc. Recent times, and this is something I've read a lot about, and it's been covered a lot in other articles and other areas in the industry, are MCAs or merchant cash advances. How do they sit in between those two groups we just mentioned in a restructure or bankruptcy, and do they make a restructure more complicated or challenging, and why might that be?
Yeah, well, I'll answer the second part of your question first, and that is, do they make the process more challenging? And the answer is yes, they make it much more challenging. A merchant cash advance is, in effect, a sale of receivables to the entity that's making the purchase in exchange for a payment of cash. It's considered, at least by the MCA parties, to be a true sale as opposed to a disguised financing arrangement or a true financing arrangement. And given that, their belief at least is that they can charge interest rates which might exceed state usury laws for the like, in as an example. There's been quite a bit of litigation over MCAs and whether or not there have been true sales and the like. But the bottom line is that the MCA vehicle is, in certain sense, it can be a lifeline to a company because it provides quick and easy cash to a business that might be struggling. The problem is it comes with a lot of strings that can choke off future cash flow and growth in such a way that it can, if not very, very carefully managed, lead to an inevitable liquidation. And in such case, then you might be stuck with a situation where the MCAs are saying, all the assets, which are in essence receivables, are now owned by us and we're collecting those. That spurred a lot of litigation as to if that's a true sale or if it's something different, which is probably beyond the scope of what we're talking about today. But I think it's sufficient to say that MCAs pose great challenges to your business. And if you're a business owner that's going through financial distress, you should talk over the MCA option very carefully with your advisors before you pull the trigger on something like that, because it can have consequences that are very challenging and perhaps irreversible with respect to the long-term future of your business.
Absolutely. A lot of cases I've seen that have had MCAs have not just had the one MCA either. There's been multiple, sometimes 4, 5, or 6 different advances there and from different MCA lenders, which just multiply the complications that you're talking about there. Also, MCAs typically are sold or pitched as being unsecured and no other kind of collateral needed kind of thing.
Hmm.
But many of them actually do come attached with personal guarantees from the owners of the business as well. I've seen several that are structured that way. So how do personal guarantees play in a restructure? Because now the actual ownership of the business presumably is tied into the business's obligations too.
Right. Well, the personal guarantees, short is, make things complicated as well. Obviously, if you're a business owner, your goal is to always have things secured by your business, not secured by you personally. But in the world we live in, that's not possible much of the time, particularly if your business is on the smaller side. Your lenders, be they traditional bank lenders, be they equity sources, be they MCAs, whatever, are sometimes just simply going to require a personal guarantee, which is a signature on a what they call a guarantee agreement by the owner, asserting that he will pledge personal assets to the extent the business fails. That can be in the form of whatever assets the owner has. It can be, for example, the stock or the membership interest in the business. It can be the business owner's house. It can be his other investments, perhaps his 401k and that sort of thing. And the problem is that when those type of assets and what in essence is an individual's wealth is tied up with that, it can make it very difficult to restructure, because to the extent that you're looking to offload debt and the like, if it turns out to be something that you have to pay personally, you're not necessarily getting ahead. And you're also can be put in a situation where you're not going to have assets to live on or to incorporate into the business as you reorganize and go forward. So it can be very challenging. The good news is with many traditional lenders, they will use the personal guarantees as a lever point to work on doing something that's constructive from the secured lender standpoint to wrap up or sell the business. And frequently you can negotiate a workout where those personal guarantees will be released. In the MCA context, however, they can be very aggressive, and that can be much more challenging.
So if you do find yourself in that kind of boat where there's your personal guarantee online and the lender is not, as you said, traditional and they take a more aggressive stance on that, are there any legal tools available, whether state laws at the federal level, bankruptcy or contract law, that can limit enforcement of those personal guarantees or help business owners to kind of, I guess, almost get out of those guarantees or kind of soften the impact of.
Yeah. Well, as you know, Nick, there's no get out of jail free card in life. And it's the same here. There are litigation options to the extent that you feel like you as a business owner have been taken advantage of or manipulated by your lenders. Those are very expensive and complicated and bespoke options. There is unfortunately the reality that in some cases the business owner might have to file personal bankruptcy. But of course, that's devastating to the individual business owner as well, and also devastating to wealth accumulation and or transfer to loved ones and the likes. while there can be things that can be done in general, to the extent you're talking about filing a personal bankruptcy, you're going to have a trustee in place, or you're going to do it as an 11, which is expensive. And in general, you're going to need to provide whatever liquid assets you have, which may include selling your home, depending on what state you're in and what homestead exemptions exist to satisfy creditors. One good news for us in Florida, at least with respect to business owners, is there is a full homestead exemption for your primary residence within the state of Florida, which at least means that in most cases, that will not be taken by creditors. But of course, in the situation of personal guarantees, like we're talking about here, you can always make a voluntary pledge of your home. And in such case, the homestead exemption will not necessarily protect you from creditors, or at least the creditor where you've provided a voluntary mortgage as part of a personal guarantee.
Excellent. So it sounds like if you do find yourself in that position, there are certain things that can be done, but there's no perfect solution that's going to completely
No,
absolve you of all obligation.
yes.
Okay, the final question: when you're dealing with a client that has pledged a personal guarantee and there's significant assets behind it, and they find themselves in a restructuring situation, have to make decisions about which route to take, Chapter 11 and the like. How do you kind of help guide them through that very emotional decision, given that they have those personal assets on the line?
Yeah, well, that's probably one of the most challenging things that a lawyer will face. And it can, in certain instances, be excruciating for the business owner, unfortunately. My advice is always to be an honest broker, to work with your secured lenders in an open and forthright fashion, work with them on a team basis, and try to figure out what's the best solution to maximize value for creditors under this circumstances. And if you do that in an open and forthright way, many lenders will work with the debtors. Not all of them, but many will. And in those instances, sometimes you can negotiate a release of the personal guarantees, or perhaps if there is a requirement to make payment, perhaps you can do it in such a way that isn't devastating for someone who's worked 20 or 30 years in industry and built something such that they can either start a new business or have something to proceed. Obviously, when you're getting into those situations, you really need to consult personal bankruptcy counsel and figure out what assets are exempt and not exempt. But it's very a hand in glove at that point between the business attorney and the personal attorney.
Yeah, excellent. Okay, well, good. That's all we've got time for now. I'm going to have to leave everybody with that. I hope you've enjoyed listening. We had Rob Folland from Barnes and Thornburg here talking to us about Subchapter 5 personal guarantees and merchant cash advances. I was your host, Nick Welch, and thank you for listening. And we'll see you next time on Turnaround Talks.
Thank you, everyone.